The past 12 years have seen enormous growth in Second Amendment scholarship and litigation. The cases and the scholarship that have come out have deepened our understanding of the history of gun regulation and of the theories and underlying normative visions for the right to keep and bear arms. But one question often goes unaddressed or at least underaddressed, perhaps because the answer seems so obvious. Why regulate guns? I think for most people, the answer seems to be obvious. It's to prevent physical harm. And undoubtedly, the physical harm that's inflicted every year by gun misuse is staggering. In the United States, about 40,000 people died last year from gunshots. Most of those, it should be self-inflicted. About 100,000 people were injured by gunshots. Again, some self-inflicted or accidental. And undoubtedly, the government has a compelling interest in preventing that kind of harm through reasonably or narrowly tailored gun law. In a recent series of papers, Professor Reva Siegel of Yale and I have been trying to explore an additional understanding, a full understanding, a recovery really of a traditional understanding of the government's interest in regulating guns, which we show goes beyond the prevention of physical harm. Guns, when they're misused, can not only end or alter individual lives, they can also distort the body politic, the way that we all live together. Guns can inflict social harms. They can impact and sometimes deter others' ability to exercise their own constitutional rights and interests, whether that be speaking, assembling peacefully, worshiping, or simply just gathering together to cast votes or to speak to government officials. And in our paper, we try to tie some of those recent examples to a centuries-old tradition of regulating guns in the name of what we call public safety that goes beyond that sort of bodies and bullets and public health paradigm. Professor Siegel and I show in our work the common law has for centuries understood that the government has a legitimate and, in our current language, compelling government interest in preventing people from the kinds of terror, intimidation, and fear that guns, when they're misused, can inflict. If we go centuries back in the Anglo-American tradition, all the way back to 1328, something called the Statute of Northampton, we see a very specific prohibition on people carrying arms to, quote, the terror of the people. It was a crime to inflict terror on the people, not just to harm them with your weapon. Today, we refer to these laws as those preventing menacing or those preventing brandishing. And I think they draw on the same kind of Anglo-American tradition. And yet, there have been recent efforts to take the bite out of those laws, to, for example, say that brandishing is only a crime when and if a person does it with the intent to terrify, or has a very specific kind of what in law we would call a mens rea requirement. That, we think, is a departure from the traditional understanding that the government had a broad scope and a broad role for enforcing limitations on weapons carrying in public spaces. So what would it look like to recover that tradition today? Would it involve courts, legislatures, law enforcers? In our paper, we argue that it's all three. To begin with legislatures, the lawmakers. When lawmakers write any kind of statute, whether this is at the state level or in Congress, they often include precatory language or findings, something to explain what the law is all about. And one thing that struck Professor Siegel and I when we were reading the precatory language involving gun statutes is that there's very little mention of the harms guns can inflict above and beyond the physical. The same kinds of questions arise when states are considering whether to expand or how to change their rules involving public carry and open carry. But the state certainly has a legitimate role in taking into account when it decides to set the rules about open carry, about where that kind of activity can take place, whether it can take place, for example, in or near schools, and the feelings of intimidation and terror that others might experience. That, we say, can also be part of the constitutional calculus and can and should go into what states consider when they write their laws. Now, what happens when those laws get challenged in court? When courts are confronted with Second Amendment questions, they typically ask a sort of two-step question themselves. One, what is the government's interest here? Is it sufficiently important? Is it compelling or at least substantial, or at least important rather? And then they ask, how closely tailored is the law to that interest? Is it narrowly tailored, meaning very closely tailored, or is it at least substantially related? In either case, the standard assumption is that the government's interest is in saving individual lives. Our suggestion is that the governmental interest should be understood in more capacious terms, that it's not just about saving individual lives from physical harm, but about preserving our social life, that is, our sort of ability to live together and exercise our constitutional freedoms free from terror, whether we are armed or unarmed, and also to take into account these non-physical harms of terror and intimidation and coercion. One other set of actors is worth mentioning here beyond legislatures, courts, and law enforcers, and that's private actors, businesses, for example, making decisions about what guns they will or won't allow on their premises, or even larger manufacturers, places like Dick's Sporting Goods or Walmart's or Salesforce.com, deciding that they're just not going to be in the business of guns, or at least certain kinds of guns, that they're just not going to put them on their shelves. It sometimes feels very difficult to find common ground in the gun debate. I think there is more already than people tend to recognize. The vast majority of Americans support simultaneously the individual right to keep and bear arms and support more reasonable gun regulation, things like background checks. I think all too often the gun debate gets conceptualized as if there is a right on one hand, that is a right to keep and bear arms, and on the other side, just sort of nebulous policy interests. And in constitutional law, we know what happens when rights run into policy interests, which is usually the right trumps. Now, again, that doesn't mean necessarily that the regulators are always going to have the last word, but it does mean taking seriously that guns have impacts even when their triggers are never pulled. And what the work I'm doing with Professor Siegel does is try to take that seriously from another angle. If a display can be sufficiently threatening to scare off an assailant, then a display may also be threatening enough to interfere with another person, non-assailant's rights to exercise or interest in exercising their own constitutional rights. Perhaps the most important question left open in the Supreme Court's 2008 decision in Heller is whether and how the right to keep and bear arms extends outside the home. In Heller, the challenger simply sought to have a handgun in his home for purposes of self defense, and the Supreme Court upheld that challenge. That is, struck down the law prohibiting him from doing so. But it didn't answer, because it didn't have to answer, the question of whether he could take that gun for purposes of self defense outside his home, when traveling to and from work, for example. The Supreme Court has yet to weigh in on that sort of general either assumption or consensus, but I think the expectation is that the court will take another Second Amendment case soon, and that question probably will be squarely presented. But what I would expect to see from the Supreme Court is a holding that the right to keep and bear arms does extend outside the home, but that it is subject to increased regulation. A common line of argument in gun rights scholarship and advocacy recently has been that the Second Amendment is being treated as a, quote, second class right, that is being subject to a different set of standards than other constitutional rights and is being disfavored when we focus in on the set of cases involving genuinely litigated and divided issues like restrictions on public carry, for example. And when we further focus just on the parties who are represented, not pro se parties, we see success rates that approximate those of other kinds of constitutional rights. And some have argued in briefs and scholarship and op-eds that the Second Amendment is the freedom that protects all the others and therefore should be subject to a level of scrutiny even higher than strict scrutiny, effectively an absolute ban on all forms of gun regulation that aren't clearly protected by historical practice. That, I think, would be a departure from how the court treats any other constitutional right and would effectively be treating the Second Amendment as supercharged. And I think would also be ignoring the ways in which the Second Amendment interacts with other kinds of constitutional rights. When people carry guns in public, in particular, it impacts other people's constitutional rights and interests. And so it's not enough to just say that because we have a constitutional right here, it trumps. There's actually many constitutional rights in play. And the hard question for courts and scholars is how to figure out how they interact and try to accommodate those interactions.